SJC-11697, in-rate grand jury investigation.
Good morning.
Good morning, Your Honors. Aaron Katz for the appellant. May it please the court. I want to first emphasize the unique factual circumstances of this case. The item that the Commonwealth is seeking with a subpoena was conceitedly delivered by the target to the appellant firm for the purpose of obtaining legal advice on a matter wholly unrelated to the criminal matter that the Commonwealth now claims a grand jury is investigating. It was within roughly a week of that the target was arrested, detained, and placed into state custody, where he has remained since that time. The appellant has retained possession of the item because there is nowhere else for the item to reasonably go at this time. And in fact, there was an admonition by Judge Locke below that the appellant firm should not do anything with the phone until obtaining final resolution of the merits of the target's objection to the subpoena. Now, given the unique factual circumstances of this case, circumstances that have not appeared in any reported decision that we are aware of, the Commonwealth's suggestions that this court should craft a reasonableness exception to the Fisher Doctrine and the Hughes Doctrine and the search warrant statute 276, Section 1, is inappropriate.
Would you be taking the same position if this were an item like a weapon?
Your Honor, the same analysis would apply to the extent that the item was passed from the target to the firm for the purpose of obtaining legal advice. Now, in many instances, that will not be the case. It will be clear that a physical item of evidence, such as a gun or a knife, was passed to the attorney simply to conceal it from the authorities. But in Hughes, it was clear that the gun was passed to the attorney for specific purposes. And so this same analysis would apply. Here, though, the court does not need to reach the question about why this item was provided to the law firm, because the Commonwealth has conceded that it was passed to the law firm for the specific purpose of obtaining legal advice.
Does that mean you can hold on to it and keep what would otherwise be available evidence forever?
Your Honor, I don't think it's forever in the ordinary case. In the ordinary case, there will be a reasonable amount of time where the law firm or lawyer can hold on to the item.
Is that a rule? In other words, you can hold onto it and conceal it and keep it safe for a reasonable period of time?
Well, at some point, the continued possession, I think a court could find that the continued possession was not for the purpose of providing legal advice. Now, here, the unique factual circumstances of this case, the most unique circumstance perhaps, is that within a week of the law firm obtaining possession of the item, the target was detained and placed into custody. And so the law firm had nowhere to put the phone, the item. There was nowhere for it to go. It had to continue to retain the phone.
Now, doesn't the search warrant statute speaks of the risk that it would be destroyed, secreted, or lost, and if those risks are present, then a search warrant may issue. Doesn't that suggest that the legislature intended that these items would be in some fashion available to law enforcement? I mean, it appears as if, as best, I've not gone back to legislative history, but my sense of this is that I think this amendment to the statute occurred after the revisions to the the Code of Professional Responsibility. And is it fair to say that the legislature understood by this amendment to say, we don't want you to search the law firm's office, go to a judge and get a subpoena from the judge to obtain this information by subpoena, and as long as there's no risk that the law firm will destroy it, secrete it, or lose it, the subpoena will be adequate in order to get the material. Is that a fair inference?
The amendment to the statute was after the Supreme Court's decision in Fisher. And so presumably the legislature understood that under the Fisher two-part test, there would be some instances in which a lawyer or law firm would obtain the evidence under a privileged communication.
Was it also after 3.8F was enacted?
3.8F cannot override the Fisher doctrine. Certainly, the Commonwealth suggests that the legislature could not have intended a scenario like this, where Fisher prohibits a subpoena from being served and the search warrant statute prevents a search warrant from being issued and executed. In other words, that the legislature simply did not foresee the unique circumstances of this case, where the law firm's continued possession is certainly not for concealment purposes, but simply because there is nowhere else to put the item. No one to...
Right, but the problem is the end result, if you're right, is that this is, for all practical purposes, unavailable to the Commonwealth. It's as if it were lost or destroyed or secreted.
We would say that the caveat that it is as if it were lost or secreted renders the exception inapplicable here, that they need to show that it is in fact secreted or it will in fact be lost, not simply that it will be unavailable. We believe that would be reading an additional word into the statute. The legislature could have if it wanted to.
Well, there's no Fifth Amendment protection in this item itself. None.
No, Your Honor, there is not. Nor was there a Fifth Amendment nor was there an attorney-client privilege protection as to the gun in Hughes, but they could not subpoena the weapon from the target in Hughes because of the active production doctrine. And Fisher, which Judge Locke below...
Well, I understand the active production doctrine, but I'm just looking at the search warrant provisions as an alternative. There's no privilege in the item itself, and your possession of it will effectively, could go forever, and will effectively deprive the Commonwealth of evidence that it is otherwise entitled to, and could get if your client had it in his possession by simply executing a search warrant.
I don't disagree with Your Honor's articulation of the consequences of holding that a search warrant cannot issue here. The item will be effectively, unless the target is released from detention and the item can be provided back to the target without the law firm risking itself to a spoliation charge, then the item will remain in the law firm's possession, perhaps indefinitely.
And do you think that's sort of consistent with the search warrant statute, that if a client runs fast enough to a lawyer's office to get the items into the lawyer's hands, they're protected from search warrants?
Well, no, Your Honor. It's not simply that the target or the client has to run fast enough to the lawyer's office. It has to be specifically handed to the lawyer for the purpose of obtaining
What am I going to do with
legal
this? What
advice.
should I do with this?
Yeah.
This is evidence. What should I do with it? Give it to me.
Well, it's not just, I mean, you've got two things here. You've got the physical item, and then you've got its contents, which are tantamount. I mean, I suggest that those are the documents, but it's also the communications that is being given to the lawyer for the purpose of legal advice. I mean, I guess my point is, even if you couldn't, even if the government never could get it, those communications would be protected anyway. In other words, if they were given, let's say it wasn't a physical item, but they were actually communicated to the attorney.
Yes.
They would be protected. So in other words, that one way of looking at this is that what it is that the government wants, it seems to me, if it were communicated orally to the lawyer, wouldn't be available ever.
Well, that's true. If for example, a client said to his or her attorney, I have sent an email, or I wrote something in my diary and here's what it says, they could not subpoena the attorney to testify in a grand jury or at trial about what the client admitted to the attorney.
Of course not, but the email itself has got no protection.
We would agree with that. We would agree that it has no protection if
It was not compelled, it was made separately and
Yes.
prior, and
If
unless
I-
it was a communication to you, but that's a whole different, that's not what we're talking about here.
No. If I were representing a bank that had the item in a safe deposit box and not a law firm that obtained the item through an attorney-client privilege communication, I would not be up here today arguing. If 276 Section 1 did not exist, I don't think we would be up here arguing.
But I guess the concern, I guess, and it's just, I think Justice Cordy has voiced it, is that if you're right, I mean, why would not, in every case where someone's under investigation for fraud, why would the attorney not say, you know, I really need to see all of your computers and all of your cell phones? That's part of what I will need to do as part of my due diligence for the investigation. Give me all of your computers and all of your files for me to review. It would be for a reasonable purpose, for purposes of providing legal advice, but it would also mean that the government would never get it.
Well, we don't think that mere labels would suffice, and we would trust lower courts after factual hearings to determine whether it truly was for the purpose of obtaining or providing legal advice, or whether
It
it
would
was.
be due diligence for any defense counsel to want to see what documents the individual has produced, which may be the subject of the investigation. It would be a reasonable thing for an attorney to do.
Ordinarily, the items will not remain with the attorney almost indefinitely. Again, those are the most unique circumstances of this
Say
case.
that under that scenario, once the investigation by counsel was concluded, that would be returned to the client.
Yes, and if it
And
were.
here,
Would
that's
that
what's
be an
different.
ethical obligation that you would have to return? What if your client said, just hold on to it?
No, I don't think it would be an ethical obligation, Your Honor, but the continued possession, a lower court would find, I would assume, would find that the continued possession was no longer for the purpose of obtaining legal advice, and so the Fisher doctrine wouldn't apply. The law firm would be no different than the
Okay,
bank
so
or
after
the
a
sister
reasonable
at that
period of time, you would be required to produce it by summons. Is that what you're saying?
that if a subpoena were served on the firm, the Fisher doctrine would not protect the target. The subpoena would be valid under Fisher because the law firm would not be in possession of the item as a result of an attorney-client communication. Its continued possession would sort of be for different purposes.
Boy, I'm very confused now. So have you completed the advice that you were providing to the client so that now you're holding it in waiting for a subpoena so you can release it?
Well, I don't think I'm at liberty to answer the question about whether.
Well, then do we have
advice
to have a
was-
hearing to determine whether the advice period is over?
No, because I think we would concede that if the target were not in Commonwealth custody right now, the law firm would no longer have the phone. That is something that we would be willing to concede. I would say that if the court believes that the Commonwealth simply has a right, must be able to get this item somehow, the search warrant statute clearly is the narrowest possible way of ruling in the Commonwealth's favor. We don't think that would be an appropriate reading of the statute, but it would be the most appropriate way to rule in the Commonwealth's favor. In that circumstance, though, the law firm would need some guidance about how it's supposed to go about handling the search warrant's execution. Does it have to lead investigators to the item? Can it walk the item down into the lobby, or does it need to stand back and let the investigators rummage through the entire office trying to find what they're looking for? It's something that the parties would absolutely need guidance on if the court went in that direction. I see I've gone well over time, and unless the court has further questions, I can cede to amicus.
Thank you.
Good morning, Mr. Chief Justice, and may it please the court. As indicated from the court's many questions, this kind of factual scenario raises a plethora of complicated issues that have been addressed, for example, in two very long law review articles over the last few years, one a Stanford law review article, one a Hastings law review article. Questions such as, does it matter why the item is turned over to the lawyer? Does it matter whether it's mere evidence or fruit or instrumentality? Does it matter whether it's a compendium of documents or computer files versus mere physical evidence? Does it matter whether the client is available to get the item back Does it matter whether the prosecution knows about the item, or does the attorney have an obligation to voluntarily tell the prosecution about it? There's a host of issues that are raised by this kind of factual scenario. A number of states have addressed this complex area by rulemaking, by a series of court decisions. California, for example, has very strong set of court decisions saying the lawyer basically has to run to the prosecutor and tell the prosecutor all about it. But this is complicated stuff. And frankly, this scenario, this 211.3 that we're here on today, is not the way for the court to be crafting a new rule in this area basically on the fly, because this court has not given guidance to lawyers and clients in the past about what happens in this kind of complex scenario. The issue here basically is whether the order below can stand or not. And based on three simple cases, Fisher, Hubble, and Hughes, it can't. And based on 276, Section 1. I mean, it's really that simple. This is not a foregone conclusion case like Gelfgat decided by this court a few months ago. Nobody has conceded that there is a phone. Certainly the target, who I represent, has not conceded there is a phone. The law firm has never stated it has a phone. Justice Locke didn't find there was a phone. In fact, at the end of the hearing, which is in the addendum, or in the appendix, Justice Locke says, Record Appendix 56, speaking to Ropes and Gray counsel, let me say that if Ropes and Gray in fact has a device at issue in this case, the order that I issued last week remains in effect. So this is all about a hypothetical item that the Commonwealth thinks exists and thinks that Ropes and Gray has. This is not a foregone conclusion case. This is not a physical evidence case, a physical characteristic case like Schmerber or Lavigny, where you're talking about blood or DNA. This is a very different kind of case.
Mr. Sultan?
This is a thorny case.
Mr. Sultan, what if not the facts of this case, but if a defendant were charged with a serious crime, and the lawyer representing the defendant learned that the defendant kept a detailed diary, and the lawyer asked the defendant to turn over the diary because there was a serious question here about an insanity defense. And the Commonwealth knew that the defendant kept a detailed diary and knew that he had turned it over to his counsel. Could the Commonwealth obtain an order for the production of that diary before a notice of insanity issued? And depending on your answer to that question, could the Commonwealth get a search warrant for that diary?
If the lawyer had it?
Yeah.
Well, I would say they could absolutely not get a search warrant for it because it's documentary and it's not being secreted or lost or messed with by the lawyer, and the lawyer's not committing a crime, so by the plain language of 276.1, they cannot get a search warrant for it. Now, whether they can get a subpoena for it, I guess, goes to, and I reread again last night, this court's decision in Gelfgat, and I suppose somebody could say, well, it's a foregone conclusion. We know all about the diary. We know the lawyer has it. We know what's in the diary. Or a court could say, well, we don't really know what's in the diary. As Justice, I think, Lenk said in her dissent in Gelfgat, the standard for foregone conclusion is stronger than probable cause. In fact, it's much stronger than probable cause, and if that standard can't be met, if you don't really know what's in the diary, but you just want to look at it, then you haven't satisfied the requisite test. Fisher still applies. Hubble still applies. You don't get it. I mean, this is very fact-specific, case-specific stuff. And to answer Justice Lenk's question about a gun, I would say a gun is not exempted under 276.1. A gun is not a document. So a gun could be obtained from a law firm by search warrant under 276.1. But this particular item, if it exists, it cannot be obtained by subpoena under Fisher and Hubble. It cannot be obtained by search warrant under 276.1. Yes, there's a lacuna. I agree. And if somebody wants to fix that lacuna, if the legislature wants to fix it, if this court wants to fix it for the future, fine. although I think it applies to a very narrow set of cases.
What are you defining as
but
what-
this is not the case to do it in.
What are you defining as the lacuna?
Well, I think a lacuna is where you have an item which is documentary in nature and therefore cannot be obtained by search warrant.
Right.
And it fits under Fisher/Hubble. That is, it was turned over to the lawyer for the purpose of obtaining legal advice and to disclose basically that the lawyer has it, and to turn it over would provide information to authenticate it and that it exists and that it belongs to the client. All that active production stuff which is clearly protected by the Fifth Amendment and Article 12. So maybe there is a lacuna, but Justice Locke basically said, look, there's got to be a way for the Commonwealth to get this. There's got to be a way, and he crafted a way. And I think this Court's questions sort of speak to the same sort of idea, that there's got to be a way to get this, folks. Let's figure it out. I don't think that's this Court's job. I think this Court's job is to interpret the law, to apply the law, and if you do that, I think that Justice Locke's order should be reversed, and this Court should say clearly that they cannot use a search warrant as an end run around
What about
that
a,
decision.
well, an end run? I don't know what an end run is, but what about this other lacuna? I mean, a phone is a phone. You make phone calls on it. Okay, you do other stuff on it too. I don't see how a phone is a document.
Well, Your Honor, I think this Court has said recently, and the Supreme Court
Got
has said...
stuff in it,
a
yeah.
phone, I mean, to call a phone a physical object, I mean, is really to do an injustice to what it is. A phone is essentially a compilation of data. I mean, it's a physical object which contains
The
data,
original,
including testimonial data.
I mean, to your point, it seems to me the original notice of the Commonwealth under 3F was, to be clear, what we want are the documents that are on that phone.
Exactly. They weren't pretending they wanted the physical object, and they don't even know what phone it is. They don't say, we want phone serial number XYZ.
Well,
They
how
say,
do we
want...
how do we even know what kind of phone it is? Maybe it's a phone like I have, which doesn't store anything. I mean,
Well,
who
the
knows?
Commonwealth, I mean, I don't know what kind of showing they made to Judge Locke, because we weren't allowed to be privy to that, and this Court doesn't have that, which is one further reason why this Court should find that whatever standard has to be met to jump through all these hoops clearly has not been met on this record, and the
Can I
order
ask
should be
you-
denied.
Can I ask you a question? All of this seems to hinge in some way on the law firm having the item, the hypothetical item, for the purpose of rendering legal advice. And how long does that situation go on? I mean, the judge made a finding here. I don't know on what basis the judge made that finding, that it was for the purpose of rendering legal advice. I
Well,
mean,
the
we're
Commonwealth-
assuming that it is
The
because...
Commonwealth basically conceded that or did not dispute that, or it was not an issue.
Does that become somehow open to question? Is the law firm continuing to render legal advice as the client is in custody on other matters?
Well, Your Honor, I guess that goes to my point about this being sort of an act of rulemaking. I know the ABA, when they promulgated a proposed rule on this, did talk about the length of time that the lawyer should have to analyze it, and then it should be returned to the client if that is possible. I mean, these are I can't answer Your Honor's question precisely because I don't want to be making up a rule on the fly either, and I don't know what the rule should be. The rule should be, I suppose, that as long as in good faith, the lawyer should analyze the object, should examine the object, and then should no longer hold it, because to hold it at that point would be arguably to be secreting it, and that's what my brother, I think, pretty much said during his argument, and I would concur with that. I thank the Court for
All
its
right,
time.
thank you.
Good morning, Your Honors. May it please the Court, Teresa Anderson and Patrick Hagan on behalf of the Commonwealth. There's a simple solution here. The Commonwealth sought a grand jury subpoena, and a grand jury subpoena should issue. This Court must start with the premise that evidence that's held in an attorney's office is not and cannot be insulated from disclosure. Physical evidence is not protected by the evidentiary attorney-client.
Listen, you don't want the phone, you want what's on it.
Your Honor, the Commonwealth needs both. The Commonwealth needs
Well,
the...
isn't your original request under Rule 3.F, doesn't it make that point specifically?
It makes the point that the Commonwealth seeks the physical item in order to conduct a forensic examination of the item.
You wouldn't seek the forensic examination if you didn't want what it was going to show, correct?
Correct, but simply the forensic examination is not enough. The Commonwealth needs the piece of evidence, and it's a piece of evidence that was taken by the target and taken to his attorney's office. And it's the piece of evidence that the Commonwealth seeks with the grand jury subpoena. The Commonwealth will seek a search warrant for the expectation of, in order to protect the target's expectation of privacy in the contents of his device. And that's where the documentary evidence will come from. It will come from the contents and from within that device. And that's where there's another protection. What's protecting the documents is, again, the target's reasonable expectation of privacy in his cellular telephone and the voluminous information and types of information that's contained in that item, in that physical item of evidence.
What do you plan to do once you get the phone? Will there be a search warrant application?
Yes, Your Honor.
And was that made known to Judge Locke when you went to him with this request?
Yes, Your Honor. It was. I think alternatively, there could be a mechanism in other instances. For example, if the target had printed out his text messages and taken his text messages to the law firm, perhaps this goes to your point, Judge Botsford, where that is a piece of documentary evidence. However, it belongs to the target. It does not belong to the law firm. And so there, a separate additional search warrant wouldn't be required. You have the physical piece of paper. You would take it to the grand jury. You would open it up, and the grand jury could see what they had requested. But the grand jury requested a subpoena for the documents for the physical item that was taken by the target to the law firm, and then no further opening, no further seizure, no further search is needed where you can simply page through those documents. The phone is a little different. The phone, where one has an expectation of privacy within that device in order to open it, in order to search it. I think we're talking about needing that second search warrant.
So what did Judge Locke find with respect to the loss destroyed? Was he concerned that the law firm would do something with the object?
No, Your Honor, and certainly the Commonwealth doesn't think that the law firm will destroy the item.
So how does that work then under 276 Section 1 if there's no concern that anything will happen to the phone?
The focus is then on the lost and the secreted part, and the longer that time goes, the longer that the evidence is becoming lost and secreted.
Well, it's not lost if it's in somebody's possession and you think you know that they have it.
It's not secreted for the same reason.
But it is not available then to the Commonwealth, and that
Doesn't say available. The idea is that you're able to get the warrant because you're entitled to it, number one, and otherwise it would be unavailable if you didn't get the warrant. So we're not talking about a lawyer who's doing his job. We're talking about a situation where somebody is trying to thwart justice. And that's not what's happening here, is it?
it is not, and I agree with Your Honor, and that's why the Commonwealth started with a grand jury subpoena. That's where the Commonwealth sought judicial approval pursuant to its ethical obligations, with an opportunity for an adversarial proceeding, for the firm to appear, for the firm to assert whether or not there were privileged communications within that item. The firm has not said so. And again, the Commonwealth does not seek any communications with respect to the disclosure of the item. And so that's where the Commonwealth started with the grand jury subpoena, that there must be a way for the ethical attorney to comply with their obligations and not hold this item in perpetuity.
So let me understand this. So you would say this item, which has no Fifth Amendment privilege surrounding it, and the item itself, no attorney-client privilege involved, once it's no longer being held for the rendering of advice, what? It should be available by subpoena, should be available upon request, should be available upon search warrant, or all of the above?
All of the above, but setting aside the purpose for which it's held by the law firm in its own investigation, they are now on notice, and a judge has found probable cause to believe that this phone contains and is material and relevant evidence essential to an ongoing grand jury investigation. I think that changes the character of the item. It's not the smoking gun, it's not the bloody knife that was first delivered, where the character is known of the evidence and its evidentiary value when it's first delivered to the attorney's office. Here it's a phone. That it's not readily apparent that that's evidence in a criminal investigation.
Would you be
If we
able
don't
to
agree
get
with-
the files that the attorney has under that same theory? Let's say you represent somebody, the case is finished, but you think there was some fraud involved somewhere and you want the attorney's files to verify that. Would you be able to do that? Would you be able to get that?
Yes, the Commonwealth could seek a subpoena. The attorneys could appear and say, within our files, these categories of documents are privileged, the Commonwealth attorney-client privilege, and the Commonwealth is not entitled to those privileged documents or any privileged communications. But outside of that, yes, and particularly where the target provides these pre-existing documents or physical items to the attorney himself, where, again, there's no protection in that item, in those documents that an individual creates. For example, the diary can...
But what about the Fifth Amendment that applies to actually producing them?
The Fifth Amendment that applies to producing the item does not transfer from client to attorney, and that is the important distinction this court needs to make in reading Fisher.
But Fisher doesn't say that.
Fisher does say that, and the First Circuit case interpreting Fisher does set forth that analysis. It's the First Circuit case cited in my brief that's decided in 2011. It's very clear that there's three categories.
Case, excuse me.
It's in one of the in re grand jury cases in a First Circuit 2011.
So you're saying that the client is put in a worse position if the client hands over the item to the lawyer than the client would have been in if the client kept possession of it?
No, Your
You're saying
Honor.
that's what Fisher says?
No. The client if the client maintains possession of the item, he maintains possession of the item. If he gives it to someone else, anyone else in the world besides a lawyer, he does not have that Fifth Amendment the Fifth Amendment act of production immunity.
But when he gives it to a lawyer for purposes of obtaining legal advice, it's different, isn't it?
It is different because he then still maintains the Fifth Amendment protection in any contents. If a Fifth Amendment exists in the contents, then it transfers to the attorney. And that's not the case if he transfers it, again, to anybody else in the world. He does not maintain the Fifth Amendment in any contents if it were to go to someone else. And that's the extra protection that the attorney-client privilege gives and it facilitates...
So give me a real-world example of what you're talking about. What about the diary situation?
The diary wouldn't have...
Contents of the diary are what you're interested in,
And
not
there's-
the physical object itself.
Correct, and there's no Fifth Amendment protection in the contents of the diary. It was not compelled. And so if that diary goes to the neighbor, again, there's no Fifth Amendment in the contents, and there's certainly no Fifth Amendment that the neighbor could assert on behalf of the target in the act of production. And so here where the diary goes to an attorney, there is no Fifth Amendment in the contents, and so that does not that would not transfer. There is also no the Fifth Amendment that the target would have enjoyed in the act of producing his own diary does not transfer. Again, I point out two other quotes within Fisher. This language is in Fisher. First is at page 402. Compelled production of documents from an attorney does not implicate whatever Fifth Amendment privilege that the taxpayer or the target may have enjoyed in being compelled to produce them himself. The act of production, that privilege, does not transfer from the client to the attorney. What does transfer is any privilege that the target has in the contents of that item would transfer. And I think you can extrapolate that further.
And Fisher also says that it is otherwise. That is, the client would have a protection if the documents were not obtainable by subpoena, ducus tecum, or summons while in the exclusive possession of the client. Then they are not obtainable if they are in the exclusive possession of the attorney.
I agree. And it certainly says that, and that must be read in context. It must be read in the context of what it's talking about is the act of production privilege. Fisher is novel for that proposition. Fisher comes out of a line of cases where the U.S. Supreme Court was willing to accept a Fifth Amendment protection in a person's private, personal papers. The Couch case, the Boyd case from 1896, I think would have said, if you write that diary, you have a Fifth Amendment privilege against incriminating yourself because that's your own private personal paper. And Fisher is remarkable for that proposition. Fisher restricted the broad and general Fifth Amendment privacy protections.
But if the Fifth Amendment protects against the production, the act of production, I think when it is given to the attorney, for the attorney to provide legal advice, that act of production privilege transfers to the attorney and can be asserted.
I disagree.
Has to be asserted.
I disagree that the production privilege transfers because the firm stands on its own. The firm is the one being asked to do an action to produce an item, and here the firm's production of the item is non-testimonial and it's trivial. There's certainly ways in which any attorney-client communication about the phone, anything that is protected can certainly not be disclosed to the grand jury, would not be used at trial, and there's mechanisms in place. First, the subpoena, to answer, I think, a previous question, the subpoena will be very specific. The subpoena will essentially set out the serial number of the device which the Commonwealth seeks. It will have the make, it will have the model, and it is a unique identifier.
You know this information?
Yes, Your Honor.
So I take it in your view, this really isn't a Fifth Amendment case, and that even if we determine that the attorney-client privilege does apply, it does not trump the Fourth Amendment, and that a search warrant in compliance with Chapter 276, Section 1, is the avenue by which the Commonwealth can obtain this item.
The Commonwealth can obtain the item with a grand jury subpoena because the physical item of evidence is not protected by the attorney-client privilege.
Well, what if we don't agree with that?
If this court doesn't agree with that, everyone should take every sort of evidence, physical, documents, and otherwise, to their attorney's office because it will then be cloaked in the attorney-client privilege.
But what about a search warrant as opposed to a grand jury subpoena?
I think that then
Are you saying that they're one and the same?
I don't think they're one and the same, but I think in that instance, when you talk about documents, you would encourage all companies to store all of their documents in their attorney's office, whether or not.
Only if it can be found that it was for the purpose of obtaining legal advice, a point you have conceded without a hearing on that subject.
We haven't disputed
Wouldn't that
that point.
be the alternative way to have some kind of a factual determination of whether or not something really was for the purpose of obtaining legal advice? I mean, I don't think that the law firms are going to agree to become storage companies.
No, Your Honor, and where you talk about putting documents in an attorney's office, you certainly do not want the standard and the first place to go being the search warrant. You want the ethical attorneys to be able to comply with their obligation. And when you look at this fact-specific hearing about why an item was turned over to a client, it could be a different case. That could be one point in time, but as time progresses, it could be held for a different reason, and the continued possession of the item could change. Again, here in this case, the grand jury subpoena should properly issue. It should have issued without a showing of probable cause, but nonetheless.
And I guess the part that I'm confused by is I thought Fisher says essentially the individual who holds the document has an active production privilege and also an attorney-client privilege, and where the information is furnished to an attorney, or should be furnished to an attorney for legal advice, the individual should not be put in the dilemma of saying, well, if I keep it, I have the privilege. If I give it over, I lose the privilege. And I thought Fisher essentially says, in order to protect the attorney-client privilege, we essentially, as Justice Botsford says, will transfer the active production over to the law firm in order to avoid that dilemma for a client. That now the client can say, okay, I can now give it to my attorney so that the attorney can provide me with legal advice, and I'm not putting myself in this dilemma of now losing my active production immunity.
I think in that instance, Judge Gansett, you're saying that then the item becomes attorney-client privileged. The attorney-client privilege cannot protect a physical item of evidence. You cannot give an item of evidence more protection in the hands of an attorney.
Not more production. It's not more protection. It's the same protection. What Chief Justice Gans is saying is if the client has an act of production, Fifth Amendment privilege, and turns it over to the attorney so that the attorney can provide, legitimately turns it over for purposes of providing legal advice, then the attorney-client privilege acts with the Fifth Amendment act of production privilege and protects it. Fisher itself, the documents weren't protected in anybody's hands. If Fisher himself had had them, they wouldn't have been protected. Fisher was the lawyer. If the client had had them, they
Correct.
wouldn't have been protected.
Correct, but taking that further, in this case, if this were Hughes.
I mean, and wouldn't have had an act of production protection is what I'm trying to say.
The act of production privilege cannot transfer. If this case were Hughes, Commonwealth versus Hughes, in which the target has a firearm and the Commonwealth sought the firearm from the target with a grand jury subpoena, there's certainly not a Fifth Amendment in the contents, but there is, the target enjoyed a Fifth Amendment in the act of producing that item. If in Hughes the firearm had gone to the attorney, that act of production does not transfer. The attorney, I think, first would have an affirmative ethical obligation to turn over an item, which is obviously evidence of criminal activity. And second, once they're put on notice that the Commonwealth is seeking this item with respect to a grand jury investigation, that act of production privilege that the client enjoyed while he had that firearm does not transfer to the attorney. I see my time is up.
That would certainly be Fisher as interpreted by In re Grand Jury Subpoena, First Circuit.
Correct. If the court has no further questions,
thank
rest
you.
on the brief. Thank you.